Today, let's talk about a very important subject, attorney-client privilege. Everybody's heard about it, but what does it mean? Why is it important? And what does it mean to waive it? And why is it really important to not do that? Attorneys are bound by attorney-client privilege. That means that the communications between you and your attorney remain confidential. And it's safe to share information with your attorney because your attorney doesn't have the right to share that information without your consent, unless, of course, you're threatening to harm yourself or you're threatening to harm someone else. And if it's a serious threat, you have to take that into account. But for an attorney to do a good job representing their client, the attorney really has to know all the facts. And that means the good facts and the bad facts. Clients really need to share all of their information, and that might mean sensitive business information, trade secrets, stuff that really does need to remain confidential. And in my 30 years of practicing family law, I often see clients either just ignored some of the bad facts, or they're too embarrassed, or they're afraid that the bad information is going to come to light, and they just won't tell us. And we think they have a great case, so we give them advice on how to proceed with their case. But the other side then refuses to reach a reasonable settlement. And our legal team will keep recommending, go for it. You can get a better judgment. You can get a better ruling from the judge. And we spend a lot of money preparing the case, and we get ready for trial. And then you get a bombshell. And all of a sudden, the opposing party discloses the bad facts. And here we are on the eve of trial, and we can't build a defense. So our legal team puts all hands on deck, and we try to come up with the best defense that we can with a short period of time. Had we known the bad facts earlier, well, we could have built a defense and tried to mitigate the circumstances. You had a drunk driving. Well, then you went to AA and got counseling. You had an outburst of domestic violence. You got anger management counseling. We can prepare if given the time. But when you've only got a few hours or a few days to reach a settlement agreement, it's probably not going to be as good as if you'd had weeks to prepare a settlement agreement because you're reaching it under pressure. And unfortunately, we see this too often, and we should have gotten the bad facts ever from the start. So share the information with your attorney. Ideally, if you've got skeletons in your closet, let's have a conversation. Discuss those in person. Sometimes you've got to tell stuff and you have to share documents of what has happened. And if you email with your attorney, those communications are supposed to be privileged, but be careful. For example, we've had cases where people email from their employer's email address. They email from their sister's email address. None of those are protected. The other side can send a subpoena to your employer. They can send a subpoena to your sister. And your information is no longer privileged. So don't do that. If you want to keep the emails between you and your attorney confidential, make sure it's your personal email account. So we understand that divorce cases and child custody cases can be really stressful. And it might be the most stressful time you've had in your life. So we do encourage you, go get people to support you. Your friends and family may be a great network to provide you with emotional support. But if you have conversations with your attorney, with your family present, you may be waiving the attorney-client privilege. So, some other things you should consider. Don't leave your attorney correspondence lying around in public places. Don't leave it at work. Don't leave it where your ex or your kids can see it. Don't give anybody access to your laptop or your email inbox. We've had it before that opposing counsel found out our strategy. Kids found stuff on their dad's phone and went, hey, I'm forwarding that to mom. That's not going to be helpful. So make sure that you have all of that protected. Opposing counsel, which is your ex's attorney, isn't allowed to talk to you as long as you're represented by an attorney. So, in other words, don't contact them. Don't waive your privilege. They don't get to talk to you. They only get to ask you questions if it's through interrogatories or at a deposition. So let's talk about waiving privilege. What does that really mean? Anytime that you voluntarily disclose privileged or confidential information in the presence of a third party, you should expect that that's not confidential anymore. So I want to come back to the bad facts issue. You may wonder, if you tell your attorney, are the bad facts ever going to be disclosed to the other side or to the court system? And in family law, it is going to probably come out. It doesn't always have to come out, but it usually will. For example, I think I mentioned earlier, if you had a drunk driving, now's the time to tell about it and fix the problem. Now, if you don't give your attorney permission to disclose those facts, they might ask you to find another attorney or that you ask you to represent yourself. Attorneys don't have the right to be dishonest to the court. Neither do you really, but attorneys aren't going to do that. We have a reputation to uphold. The courts know we're going to be honest and we're not going to lie for our clients. So if you have bad facts, have a strategy, know how to deal with them. You may want to disclose them on your terms at your time, but they're going to come to light. And so you need to be honest about your bad facts. Ultimately, privilege belongs to the client. It belongs to you. So if you decide to waive it, that's your call. In sum, this is an important subject. Don't accidentally waive privilege by allowing people access to your emails or using the wrong account. Have a strategy with your attorney if and when you're going to waive privilege. Otherwise, at least keep all of your confidential information confidential. Until next time.